Well, good morning and welcome to the January docket of the Kansas Court of Appeals. We have three cases this morning on our docket. As counsel know, each side gets 15 minutes to argue. The appellant has the opportunity to reserve some of that time for rebuttal. So just let me know in advance of your argument whether you want to preserve any time. I'm honored today to be presiding over this panel probably on your left as well on the screen. To my left on the screen is the Honorable Henry Green, who is the longest serving judge on the Kansas Court of Appeals. He's been on the Kansas Court of Appeals since 1993. I have no idea how many cases he's heard, but it has to have been thousands. And on my right side of the screen, hopefully yours as well, is the Honorable Gordon Atchison. Judge Atchison went on to the Kansas Court of Appeals about a year before me in 2010. And I see that he's heard more than 1,500 cases already. So I dread to think of the number that Judge Green has heard over. We have an experienced panel. And as you know, counsel, we've read the briefs, so we're familiar with the facts. So if there's anything you want to summarize, certainly you can, or things that you think are significant to the issues presented. But if you want to just move right on into your legal arguments, that is fine. So would you please state your appearances for the record in the case of, I'm going to butcher this name and I apologize, Waliallah versus State of Kansas.
May it please the court, Wendy Miller appears on behalf of Mohamed Waliallo.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state.
Thank you. And Ms. Miller, do you wish to preserve any time for rebuttal?
I'd like to preserve 2 minutes if I could, please.
You may do so. So when you're ready, you may proceed.
Yes, on December 11th, 2012, Mohamed Waliallo was charged with 1 count of robbery and 9 counts of aggravated robbery. At the time of his plea, he was represented by counsel Bizzotti. He asked counsel if he would try to secure a plea deal for 5 years. Mr. Waliallo received a letter, and this letter is part of the record. And I call it the Sorry Joe letter because in the letter, Mr. Bizzotti quotes the prosecutor explaining, sorry, Joe, your guy is looking at 35 years. And Mr. Waliallo contends that this 35-year number was the only thing that anybody had ever told him with regard to the maximum penalty that he was facing. And eventually, at a 1507 hearing, Mr. Bizzotti was asked if he had discussed the maximum penalty with Mr. Waliallo, and he indicated that he couldn't recall a specific discussion with him, but that his normal practice, of course, was to do so. So with the maximum penalty, Mr. Bizzotti agreed, as he was originally charged, would have been a level 3 at a criminal history A would have carried, could have been up to 494 months, of course, with the 247 maximum penalty being doubled. And so the best evidence that we have is him, counsel stating that he didn't recall if he had discussed that, but that was his normal practice. And then the cases that we rely on, Earls was a case where he had filed a 1507 indicating that counsel had not discussed the maximum penalty with him. And counsel, Earls was counseled, and counsel, like counsel here, couldn't recall that it ended up, the court found in Earls that the best evidence was that counsel might have discussed the maximum penalty and that wasn't sufficient. And so finding that counsel was ineffective, Importantly, that the standard in Earls is important here, because here in this case, the district court in the 1507 hearing found that counsel wasn't deficient, but found that the standard for prejudice was or indicated that he got a good deal. And in Earls, of course, they go over the standard that the question is, whether given the deficiency, whether the client would have entered into the plea and instead gone to trial had they have known of the maximum penalty. So that standard is important. The other thing I wanted to address is that the district court found that although Mr. Waliallo probably had a better memory, that the court didn't find his testimony credible, and that he relied on the record and the plea colloquy for finding that. So I don't think that conclusion is supported by substantial competent evidence. If you look at the plea itself, there's no maximum sentence discussed. I mean, the exposure isn't discussed. It indicates that the parties would agree to an amended complaint to run the first 3 counts of an amended complaint consecutive, which would be 192 months if you took the low number on the main count, the primary count, which was 130 months, and then you took the mid number, or 31 months, on the additional 2 counts, the non-base sentences. But the plea agreement does not give the maximum penalty. Neither the original complaint nor the amended complaint gives the maximum penalty. And then what's given in the acknowledgement of rights are ranges, 31 to 136. But if you look at the journal entry, that's actually the correct sentencing range for each count. As far as what his maximum exposure was, you look at the journal entry, and that tells us that for the main offense, the primary offense, it's anywhere from 122 to 136, and then on the additional non-base offenses, it's anywhere from 31 to 34. And what's given in the acknowledgement of rights is 31 to 136. So that's inaccurate for each count.
Ms. Miller, let me ask you a question. Just to refresh my recollection, was the maximum penalty or maximum sentence articulated on the record at the sentencing hearing? And if so, what was articulated?
The district court judge indicated that each count would carry a sentence of 31 to 136 months. And there was no discussion of the effect of the double rule, which would have limited the base sentence to, or would have limited the sentence to twice the base level. And there was no explanation of that. Mr. Waliallo, if you look at the case, not Earls, Helms, the way that the judge had gone over the sentence in that case, and that case is distinguishable in that Helms did not have counsel, okay? But if you look at what happened in that case, the district court gave a range, a sentencing range for the multiple conviction case for the counts of 7 to 23 months for a total of 46 months is what the district court told Helms that he was facing. But the problem was that with the criminal history considered, that he was actually facing 7 to 23 on the primary offense, and then 7 to 9 for the other 2 offenses. So instead of the 46 months that he was told he was facing 14 to 32 months.
I'd like to go back to the question of the district court's credibility finding here. I mean, you touched on that, but it seems to me that's fairly significant. As I understand it, you have the public defender, Zadi, testifying, look, this happened 5.5, 6 years ago. I don't recall the details of the conversation, but I had a practice I followed in every case of explaining maximum sentences and going over that in detail with the client. And I did that all the time. And there was nothing about this case that would suggest to him or generally that he would not have done that. I mean, he was fairly adamant that he followed his standard procedure, which would be to discuss the maximum sentences, which would be part of an expected conversation. Waliallah says otherwise. And I mean, the judge allows that Waliallah probably has a better recollection of this particular case because it's his case, but that he has obviously a vested interest in the outcome here that Zadi doesn't necessarily have. And the judge makes a fairly explicit credibility finding in favor of the trial lawyer. And I'm a little troubled about how we're supposed to get around that. I mean, you touched on that. It seems to me that's a critical issue, especially as a predicate to everything else. Could you elaborate on why that is not a credibility finding that we have to respect?
Well, if you look at the judge's decision, he bases that in part on the record, on the plea proceeding itself, and then the plea documents. That to him weighed in his determination on credibility. But as
certainly, but he also saw both of them testify and took that into account. And that's where we run into a problem in terms of second guessing a credibility determination where there's live testimony. If it were just a document case, your point would be certainly considerably stronger. But what do we do with a situation like this where he's seen and heard both of these people testify in front of it?
Well, I think we look at everything, and if you look at everything, then you can see Mr. Waliallah's testimony matches up with what the evidence is, and the evidence, like the Earls case, was that ultimately his attorney couldn't remember. He couldn't remember a specific discussion with him explaining that to him. But what's additional in Earls is that 35-year letter that Mr. Waliallah had, and there was no evidence really to dispute that. There was no evidence, for example, of a letter where, it said, you're facing 494 months, and if you take this plea, this is your maximum penalty. So I think if you look at his testimony, Mr. Waliallah's testimony, it's very consistent with what the record is, and the finding, that the evidence was that the attorney didn't remember is exactly the same as in Earls, where they found that wasn't sufficient. So it's the same thing, but it's plus more because the only other evidence of what he was advised as far as the max was the Dear Joe letter or the Sorry Joe letter.
Okay.
And then the other issue that I wanted to point out, you look at was counsel ineffective, but you look at also, did the district court advise him of the maximum penalty? And it's our position that the sentencing range that was given, the 31 to 136 months, did not comport with 22-3210A, and there's got to be you've got to have 4 requirements to accept a plea, and it's got to be done in open court, and it's got to provide the defendant with the sentencing guidelines level and the maximum penalty, and then you've got to address him personally to ensure that he understood that, and that wasn't done here. And then, of course, there has to be a sufficient factual basis, which isn't at issue here. But it's still our position that because counsel couldn't remember what he did, and because the district court did not give him the maximum penalty, counsel can't fix the fact that the district court didn't provide him with a maximum penalty by simply saying he doesn't remember in the plea records. Doesn't fix it either. Happened at the colloquy or in the plea or by counsel, and nothing suffices to honor Mr. Waliallah's due process rights. So it's two issues. It was counsel ineffective, and was there a due process violation when the district court failed to provide him with a maximum penalty? And then we also,
Ms. Miller, you're just a little bit over your 13 minutes. So if you want to reserve a couple for rebuttal, you might want to summarize and wrap this first part up.
yes, and I just lastly would say, if you read our reply brief, we give you the reasons why the state had argued that somehow the issue of whether the district court had comported with due process when he accepted the plea, did he comply with 3210, that wasn't an issue. And if you look at the 1507 record and what Mr. Falk, who represented Mr. Waliallo during the 1507, I don't see anywhere where Mr. Falk abandons that issue. There was clearly no waiver or abandonment by Mr. Waliallo. I think the only issue that was abandoned, if you look at the record, was the issue that dealt with the Wyandotte County convictions, which wasn't an issue at the 1507. There had been a prior order. So with that said, also, if you guys would look at our supplemental authority, where the attorney stood silent when the district court didn't provide the maximum penalty, is the same thing that happened here and was insufficient. Thank you.
Thank you, Ms. Miller. Ms. Kuhn?
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. The issue before the district court was whether defendant's attorney properly informed him of the max penalty for the crimes that he was facing in the plea. And Judge Atchison, you hit on a very important point, and that is the fact that the district court did make a credibility finding. And based on everything that he saw at the evidentiary hearing, he found that the defendant was not credible and that his statements, he did obviously had a vested interest in the outcome of this, and he was biased. And there's nothing here to indicate that this court should overturn or disregard that credibility finding. It's our position that the evidence before the district court showed that the defendant understood the consequences. He understood the max sentence. He was fully informed by the court and his counsel of the possible consequences of the plea and the maximum sentence. His trial counsel.
Ms. Kuhn, I mean, a point of fact, at the plea hearing, the judge did not discuss the maximum sentence. Specifically.
From my reading of the record, the district court went over, like any district court judge does at a plea hearing, the possible range for the counts that the defendant was pleading to. Because as we know, at the time of a plea, the PSI hasn't been done. While we believe this individual was an A, you have to do the PSI to determine.
Right. But what the judge did not talk about and this is a multiple conviction plea. I mean, that's the result of it, obviously, that the double rule would apply and cap at twice the maximum of the base offense. And that was never discussed by the district court with Mr. Waliallo, right?
That was never discussed by the district court. But the district,
is that a problem?
I don't believe that's a problem. And I would turn to Mr. Bizzotti's testimony, where he did talk about his general practice and then even spoke to the fact that while he couldn't recall specifically in this case because there was nothing memorable. He did testify that his signature on the plea documents, the acknowledgement of right and the plea document, was proof that he went over that document with defendant and explained the double rule to defendant.
Okay, well, let me be a little more precise with my question. Was it error for the judge not to have explained the effect of the double rule in a multi-conviction case? You're arguing or explaining to me why it would be harmless. Is it error?
I don't believe it is error.
Okay, and why not?
I don't believe that we have something saying that in a at least to my knowledge, in a multi-count case that the district court is required to go over the double rule, at least in my recollection at this moment. I'm not recalling that. But if there is, as you noted, we do have evidence that the prosecutor, the defense attorney went over that with defendant and explained it to him. We also have the judge explaining consecutive versus concurrent to the defendant at the plea hearing, and the defendant indicates he understood that as well. Again, there is nothing here besides the defendant's self-serving statements that would point to the fact that he did not understand the consequences of his plea. He wants to point to the letter that Mr. Bizzotti wrote to him, but even his attorney explained that letter, the statement regarding the 35 years, was made by the prosecutor. Mr. Bizzotti did not hold that as being the maximum penalty that defendant could have gotten. Instead, he put that in the letter so that the defendant knew the prosecutor's response when he went to him with this request for a plea of 5 years, to show movement that it was unlikely that the state was going to give defendant what he wanted. The evidence here is that defendant really only had an issue with this plea after the court sentenced him and decided not to follow the agreement that he had entered in, the plea agreement that defendant had entered into. There's nothing here to show that counsel was not competent, that his representation was deficient, or that defendant was misled or coerced. Defendant signed the acknowledgement of rights in the plea form, defense counsel even indicated he would not have signed it if he had not gone over that document with defendant. And he indicated that he has never simply handed a form of that nature to a client and just told him to sign it. So the evidence indicates, as the district court found, that defendant was fully informed of the consequences of the plea. He was fully informed of his possible sentence, and he chose to enter into that plea to save himself from the exposure of a lengthier sentence associated with the original charges that he was charged with. And as the district court found, this claim did not rise to the level of manifest injustice to allow the withdrawal of defendant's plea. Additionally, the claim that the district court did not advise him, or that the issue was that also that the district court failed to advise him, that was not before the district court at the evidentiary hearing. At the outset of that evidentiary hearing, the parties indicated that they were there for the court to determine the issue of whether movement's attorney improperly informed him regarding the maximum penalty that he faced and whether his plea was knowing and voluntary. Both the state and defense agreed that that was the issue before the court. Then at the conclusion of the hearing, the district court also repeatedly stated that was the issue before it. And at no time did defense counsel say, wait, we also need a ruling on the issue of whether the court properly advised defendant. So it is our position that that was not before the court. And additionally, the defense never objected for the court to make a finding of fact or a conclusion of law on that issue. And nonetheless, with the findings that the court did make, it found that defendant had been advised by his own counsel, and he was aware of all the consequences with his plea. So it is our position that the district court did not err. It did not abuse its discretion in this ruling, and we would ask this court to affirm the ruling of the district court. Thank you.
Thank you, counsel. Any further questions from the panel? Okay. If not, Ms. Miller, you have a couple minutes for rebuttal.
Yes, on the acknowledgement of rights form, Mr. Waliallo contends that he did not have that form ahead of the plea, that he got to the plea proceeding where counsel met him with the form. Counsel didn't read the form to him. Counsel gave him the plea the acknowledgement of rights a couple minutes before the plea was taken. And it was signed, if you look, on the same date of the plea on the 23rd and then filed on the 25th. And Mr. Waliallo contends counsel indicated this just goes over what we discussed. On the consecutive versus concurrent sentences, Mr. Waliallo's understanding was that some of the counts in the plea would be consecutive and concurrent. But as far as the maximum exposure that he was going to get, he didn't know that. If you look at the plea agreement, it talks about that this case was going to be consecutive to the Wyandotte cases or whatever other additional cases were out there. And then, the best evidence that Mr. Vazzotti went over anything is his statement that he didn't recall. I mean, and if you really look at Mr. Waliallo's testimony and you compare it to the record, I mean, it's just continuously consistent through the colloquy, the documents, and all of it. So he didn't get the acknowledgement of rights until the time of the plea. He had time to contemplate 192 months, but whether it was consecutive or concurrent didn't matter to him because he thought 192 months was the deal. So he didn't, the evidence does not show that he was advised of the maximum penalty, and even the district court sentencing range that was given was incorrect. And then again, we would rely on our reply brief that Mr. Waliallo hasn't waived, the due process issue with the district court's failure to give him the maximum penalty. And it's part and parcel of determining whether counsel was ineffective. You have to look at everything and decide whether he should be allowed to withdraw this plea. And that includes, as was argued by Mr. Falk, that the district court failed to give him the maximum penalty and just gave him the range that he did so. Thank you.
Thank you. Any questions from the panel? Well, thank you both. We'll do our best to get a decision out to you in a timely manner. We appreciate your arguments, and we'll take a short break and then come back to our next case, which is a civil case.